Welcome, everybody, to this panel, the DSA, as I told you, the fight against gender-based violence. My name is Gloria González Fuster. I'm a research professor at the Free University of Brussels, VUB. I have the pleasure of organizing this panel on behalf of LSTS, which is a research group that which I am the director. LSTS stands for Law, Science, Technology, and Society, and we are an interdisciplinary research group at the Faculty of Law and Criminology. I will do a longer introduction than usual, just to give some time to people to come in, so you can be prepared for this long introduction. Basically, to tell you that this panel is somehow another panel in a series of traditional panels that we have been having for many years about something related to gender. So some years at CPDP there are many panels with a relation with gender. Sometimes there is only one, and we make sure that there is at least one, and it is this one. And within this series of panels, we have had already some of them about this specific question of digital violence, online violence. So why do we keep having panels about this subject? Because, of course, the problem is not being solved yet. So the day that it's solved, we will have less panels. And one of the questions of today is the problem not being solved? Is it even getting worse? I don't know. I was trying to think about the year that has passed by. If we can think about things that we might remember about this year, I don't know, what do you remember? I remember this big declaration from Mark Zuckerberg, our friend, who said, we need more masculinity on the internet, and the internet, okay, that's some of the highlights of the year. Another year, fun fact was these Tate brothers who are accused of, I think, very serious stuff, flying around the world like nothing happened. I think the atmosphere is an interesting atmosphere to be thinking about this question of gender-based online violence, digital violence. So this subject is interesting because it is an important subject, but also it's interesting because we know it is a problem, and sometimes the solutions that are proposed can be potentially also a problem. So we have the problem and the problems of the solution. Why is it a problem? I suppose I don't have to insist too much on this, that you know that especially with the DSA, we were promised that if we have rights offline, we have rights online. Do we have, all of us, exactly the same rights offline? Let's assume that we do, just to simplify the debate. Let's assume we have the rights. But of course, if you go online and if you are harassed, your rights are really not that useful. If you go online and you are intimidated, your rights are not that useful. If you go online and you have to deal with the fact that your classmates have been using an app to create naked pictures of you and are sharing this, and society is saying, congratulations, you use modern technology or something like this. There are many situations in which actually your rights are not really a reality online. So can the DSA do something about this? This is one of the questions that our speakers will be tackling, and also this question of what are the possible problems that we have in trying to address the solutions. We have here with us four great speakers to discuss this question of the DSA and other questions. I will briefly introduce them just in the order of appearance. We have first Elisabetta Stringhi, who is here. She's working with the Italian Data Protection Authority, not representing now the Italian Data Protection Authority, representing herself as a researcher working on these matters. So welcome. Then we have Asha Allen, who is very well known, I think, in these policy discussions I think, director of the center, CDT, Center for the Democracy and Technology Europe. So welcome. And you are very busy this week, so we are very, very happy that you are here. Then we have, now this is the greatest pronunciation challenge of the year, Alexandra Kucherava, who is also very well known in this area, working as an academic in the area of freedom of expression and assistant professor of ICT law at the KU Leuven. Welcome. And then we have as our more international speaker coming from Pakistan, Faricia, yes, Aziz, maybe I just wrote it, co-founder of Bolo B, that is the name of an NGO working on digital rights. She's also a journalist, and of course, journalists are generally also very interested in these discussions of online gender violence. I said it was going to be a long introduction. I hope now everybody's here. I will now put a lot of pressure on these speakers so they are short. Why? To give you time to ask questions later. I really hope that you will have questions. I might also have questions. I have to tell you, contrary to other panels where the speakers know the questions in advance and then they pretend they don't know the questions, here they don't know the questions for real, so also I don't know them myself. This is a panel which is for real, so please engage in this exercise. We will listen and have questions later. But with this, Elisabetta, please have the floor.
Is it working? Yeah, okay. So good afternoon. It's a real pleasure to take part in this very important panel today with these really prestigious panelists and this esteemed moderator. Thank you. So our task today is to explore whether the DSA is actually fulfilling its promise as an effective instrument to counter gender-based online violence, and if not, what actually must be done to get there. So I have a really brief intervention to introduce the discussion before leaving the floor to our other panelists. So I will briefly touch upon three key speaking points: the structural challenges of the DSA as a legal instrument, the enforcement actions that are actually needed to ensure coherent and effective application of the regulation, and finally, the interaction of the DSA with other instruments such as the GDPR and AI Act. Of course, before I start, I'm actually bound to say that all the views that will be expressed during this panel do not reflect the official position of the authority. So I'll begin with the first talking point. So the inherent limitation of the Digital Services Act. So here I briefly focus on three key main issues. So the first actually key issue here is the restrictive framing of illegal content with regard to gender-based violence, because as we all know, the DSA heavily relies on the notion of illegal content as per removal obligations. However, we also know that gender-based cyber violence is often perfectly legal content, which is still, however, really harmful, such as, for instance, misogynistic slurs. Secondly, another key issue of the DSA is represented by the fact that it relies on the quantitative threshold for very large online platforms. What I mean here is that we all know that crucial due diligence obligations such as the risk assessment and mitigation, adoption of mitigation measures, so Articles 34 and 35 apply to platforms who have a certain amount of active users per month, at least 45 million average users in the EU. This is a very high threshold, which actually leaves out several online platforms out from these key due diligence obligations. And this is actually quite a troubling aspect, because even if platforms are smaller, they could be still as crucial in fostering this phenomenon. And finally, another structural challenge regarding the DSA is also the problem regarding the dissemination to the public criterion. So we all know that the obligations of the regulation are closely tied to the idea of public dissemination. However, what about private messaging platforms, such as WhatsApp or Telegram, platforms that would be typically excluded? But what about, for instance, large channels where there are millions of hundreds of thousands users active? And even if we try to cover also these messaging platforms, of course, there will be other possible tensions with other legal instruments. What about privacy challenges there? Moving on to the enforcement aspect, there are several actions that could be actually taken to ensure coherent and effective DSA enforcement. First of all, a problem is that we currently are missing a legal and wide definition for gender-based online violence. Now the GBV directive has actually introduced many legal definitions for several forms of specific forms of online violence, such as image-based abuse or cyberstalking. So one step forward here could be also to avoid possible fragmentation of the framework, to adopt guidelines in order to a bit guide the enforcement action and also, of course, the operations of platforms. Another step forward would be also the encouragement of the adoption of EU codes of conduct, which could be sector-specific. So we could have, for instance, codes of conduct specific for the pornography sector, codes of conduct specific for the social media platforms, etc. And this could actually include several potential suggestions as per measures to mitigate this systemic risk, such as a revision of user experience or revision of terms of services in order to encompass a broader range of cyber violence forms, improving human supervised content moderation, etc. Also to ensure meaningful enforcement of the DSA, we could probably learn from the past and from the enforcement of GDPR. Something that we have actually learned is that sometimes it's quite better to go beyond the mere economic logic of fines. We've often seen in practice that corrective measures are the real measures that have actually helped in shaping the business conduct of platforms. So this could probably be a way forward. Finally, I'll briefly highlight two important challenges regarding the interaction of the DSA with GDPR and the AI Act. About the DSA and the GDPR, we know that in theory, the two regulations would not overlap. However, often in practice, what happens is they actually do. With regard to competence and governance, I'd like to show you briefly the Italian case. In fact, since 2017, the Italian DSA has been tasked with a mandate to act on cyberbullying content. Since 2019, it has been tasked to do the same with image-based abuse content. However, recently, the Italian lawmaker gave another independent authority, AGCOM, which is the Independent Authority for Communications, the corrective powers under the DSA, and it has been designated as the Digital Services Coordinator. So you can see here quite a paradox. The Italian Garante has still like the mission, but not the powers to actively act on it. We have the opposite problem with AGCOM. AGCOM has the powers, but not the formal mandates. And this could lead potentially to important conflict problems and duplications also of proceedings. Yeah, I'm seeing the slides going. Yeah, okay. So finally, another challenge surely will regard also the coherent enforcement of the DSA, also with regard to the AI Act, because as we know, the AI Act has also introduced important obligations regarding transparency with regards to deepfake technology and also a wide set of rules regarding general purpose AI models. And we know that these technologies have been highly implicated in the cyber violence. So I think that a really key challenge ahead will be actually ensuring the coordination of the two legal instruments.
Should they move the slides? We can have them.
Yeah, sure. But I'm at the end, so yeah, no problem. So.
Thank you very much. I'm sorry the slides.
No problem. So thank you, and I'm really looking forward to engaging with you lately and answer questions.
Thank you very much. The slides were a bit slower than you, but you were perfectly on time, so thank you. I hope this was informative. We are now a bit situated in the general landscape, and I give the floor to Asha for remarks. Thank you.
Sure. Thank you very much, and thanks for the overview. Yeah, this, as you mentioned, this is a topic quite close to my heart. I've been working on this for a decade now, so showing my age a little bit. But yeah, so there's a few reflections that I wanted to actually tie to the presentation that you gave in terms of setting the landscape in terms of the DSA as a tool. And I outlined the fact that first and foremost, even though the DSA is in place and we're 2 years into enforcement, we're only just beginning to see some of the fruits of its labor, let's say. We've got the first risk assessment reports that came in November only, and we're looking at the second round happening right now. You mentioned the very large online platforms, and 3 of them were designated later, 3 of them which I think are very pertinent to this conversation, which are platforms that host pornographic content, and they were designated a long time after the previous one, so they haven't really done their first risk assessment reports first. So that's pretty interesting. But in terms of the conjunction of the DSA with other specific forms of legislation, I really do want to zoom in on the directive on violence against women and domestic violence. And first and foremost, I just want to give a shout out to all the rights organizations who pushed for this, because this has been 20 years in the making, that directive. And finally seeing it come through is a really big, important piece of work. And one thing to note about that directive is, even though it tackles violence against women more broadly across the EU and sets criminal standards for certain forms of violence against women which are recognized as EU crimes, its legal basis is based on 2 aspects of the treaty for the functioning of the European Union, and one of those is computer crimes. So out of the 7 articles that outline what's criminalized in the EU as a form of violence against women, 4 of them are cyber violence, and the other 3 are not. So it's quite important in terms of that particular context. But where the 2 intersect is where I'm going to lean in on this illegal content and the harmful content aspect that you spoke about, because the DSA is really the tool and the vehicle that we could potentially use to tackle that harmful content that doesn't amount to the level of illegality. And it's important to set that precedent, right? Because with all of the systemic risks in the DSA, we're dealing with quite normative issues where we're balancing rights. We're balancing the right to privacy, the right to freedom of expression, the right to non-discrimination, the right to access to information. And the reason the DSA isn't entirely prescriptive in terms of what it outsets in terms of methodology is because we're dealing with those issues that are iterative and will change over time. And so those due diligence obligations for the very large online platforms, it's important to note that several of them, and some of the largest ones that we're thinking about, I say had, because they've removed them recently, but had put in place some measures specifically on online gender-based violence and kind of how to tackle issues such as harassment targeted towards politically engaged women, which was some initiatives. We've had some changes in certain hateful conduct policies at the beginning of this year that's completely reversed some of those moderation practices, but we can get into that a little bit later. But where we're looking at the forms of illegal content, the directive is quite clear in that cyber stalking is a form of that reaches criminal standard. I believe the non-consensual sharing of images, dissemination of images. We have cyber harassment and cyber incitement to hatred. So for those of us at CDT, we very much welcome that some of those provisions actually align with the Istanbul Convention, which is something I wanted to come back to in terms of the definition, but we can come back to that in a moment, because there are some aspects that we very much welcome, but we are concerned with the cyber harassment provision. You can probably guess what I'm going to say on this. But when you're trying to do the balancing of rights and thinking about preserving the freedom of expression for those who most need it, right? We're talking about women, gender non-conforming folks and communities who are minoritized. When you have a provision like the one you have in the directive on cyber harassment, we are quite concerned because, and I want to actually read it out to you because I don't like misquoting EU law. I love EU law, so I don't like misquoting it. So for the cyber harassment provision, it says that member states shall ensure that the following intentional conduct is punishable as a criminal offence. And Section A of that provision is the repeatedly or continuously engaging in threatening conduct directed at a person, at least where there is such conduct involves threat to criminal offences by ICT services, where it's likely to cause severe harm or for a person to fear their own safety. This aligns very much with the international human rights framework. However, immediately after that, it then says it's also a criminal offence to engage, together with other persons by means of ICT, in publicly accessible threatening or insulting conduct directed at a person, where it's likely to cause psychological harm. That standard for it to meet a criminal offence or for a person to feel a threat to their life is not repeated in that second part. So then we have this question of, okay, so what does threatening or insulting conduct mean? It's then not defined in the law. So the way that I try and package this in a way that's most accessible is imagine that Me Too can't happen again. Because you are thinking about someone who may call out their perpetrator, and they may have communities coming to defend them, and that person could argue, they are threatening me and insulting me, and the law isn't prescriptive enough or descriptive enough in order to prevent something like that. So where it comes to the legal forms of online gender-based violence, we have our concerns, as you can imagine, as an organization that advocates for free expression. But saying all of that, the EU does have the most comprehensive legal framework to tackle gender-based violence online. If you acknowledge that certain forms of online gender-based violence amounts to illegal content, but is also harmful content, you can use the DSA and the directive together. And the last thing I'll say before very quickly passing it on is that I understand a code of conduct on gender-based violence is in the works. It's been in the works since 2017, so hopefully we'll get that pretty soon. And very much agree with you on the human rights-centered enforcement of the DSA. I don't think we want to call for just strong enforcement of the DSA. We're calling for platform accountability. We need to have accountability over our regulators as well. But ensuring that those issues that I just mentioned, where we're concerned about enforcement overreach that doesn't harm communities, is quite important. But I did have some other reflections on other things you said, but I want to make sure our colleagues have time to input. Thank you.
Thank you very much. I see that Alexandra just took directly the microphone, so I don't have to give you the floor. Just please.
I can wait.
No, it's very fine. I think this question of the enforcement is a theme that is really very, very interesting. You just said we can use together the DSA and the AI Act. Of course, in principle, we can use many things together, but in practice, who uses what, in which is many, many questions. But please, Alexandra.
All right, thank you. So I would like to continue on more practical measures that can be taken to address the problem of gender-based violence, but also specifically to focus on porn platforms. So recently, Pornhub, which is now a VLOP under the DSA, informed their creators that they will remove all content that does not meet requirements on performer's ID and also proof of consent, and that they are planning to do that by the end of June this year. And most likely this will lead to a removal of huge amounts of content, videos, potentially a largest purge of content since 2020, when they removed something like 10 million of their videos. So this move is considered a direct result of the obligation to assess and mitigate systemic risks related to illegal content, but also gender-based violence under the DSA. Pornhub is the only VLOP right now, I think, that decided to do that. Some organizations, for example, Digital Intimacy Coalition, is saying that that's the first real sign that the DSA is being taken seriously by the adult tech industry. And while it's being applauded, it's also pointed out that actually all porn platforms should do that, and that verifying consent should not be optional, but basically a baseline necessity. There are some more critical voices calling this smoke and mirror. First saying that the verification measures that are now required are rather weak and can be circumvented easily, and the consent can be forged. But most importantly, that this move comes after years of backlash and lawsuits. Right, so in 2020, the New York Times revealed that Pornhub had hosted huge amounts of videos that showed children, that showed rape, that showed revenge porn, and other forms of non-consensual material. And that led to removal of over 80% of their videos. And in 2023, Pornhub was prosecuted in New York for having profited for years from pornographic content that depicted victims of sex trafficking. That was related to the production company Girls Do Porn. So it's not exactly like there was no sign that there could be or that there is a problem with content that is being uploaded to such platforms. And then talking about porn platforms more in general, large porn platforms do describe in details their policies on preventing non-consensual material that is being uploaded, but it's still easily accessible there. If you check it, there are categories that specifically say, refer to material that is basically image-based sexual abuse, upskirting, spy cams, revenge porn, leaked or stolen material. And so some organizations, for example, European Women's Lobby, describe all porn as a form of violence against women. They say it objectifies women's bodies, it promotes damaging stereotypes, it normalizes violence and promotes sexist and violent power relations. And for these reasons, they advocate on abolishing all pornography as a way to protect women's rights. But this position is considered rather radical and is also criticized by some members of sex work community. And according to them, such stance on pornography reflects outdated moralistic views of sexuality, and it can actually contribute to further marginalization. It also overlooks the argument of agency, which centers on the idea that people that perform in porn can act with autonomy, intention, and self-determination. And it calls for more complex discussion with respect towards sex labor. So, for example, scholars such as Zara Stardust, who's an author of a book on indie porn, she describes alternative forms of pornography, such as fair trade porn, ethical porn, or feminist porn, which she calls form of resistance to mainstream pornographic practices. So this type of porn follows values and practices such as ethical labor, including fair pay, transparency, consent, performers control, and also anti-exploitative production models. And it also includes marginalized identities, body types, sexualities, and genders in an attempt to dismantle the harmful stereotypes about them. If present on large porn platforms, this type of content is often deprioritized in search and algorithmic recommendations, and it's making it hard to sustain visibility and income, and basically leading to further structural silencing. But it's true that mostly this type of pornography exists outside of the mainstream platforms like Pornhub. Fair trade porn generally is distributed through alternative, independent, and small platforms. I'll stop here, but that's something that I wanted to add to make that discussion even more complicated. Thank you.
Thank you very much. Indeed, we are going to add some extra layers of complexity. So we are not just discussing the DSA, which is complex enough probably. And Faria, you have now the floor. You bring us this more international perspective, but also your experience in doing some help with victims of violence. Thank you.
Thank you. I think the crux of the matter is that we know the prevalence of GBV online, and now the buzzword is tech-facilitated GBV, right? So every now and then we'll hear different terms, but the question is, how do you adequately address this? Platform moderation policies, of course, have been under scrutiny for quite a while now. From the Pakistani context, at least I can say that while, there's discussion in the DSA, and I've heard colleagues also speak about, criminalization or inclusion of certain terminology such as, recognizing it as an offense, right? That's essentially what a legal framework is supposed to do, so whether it's cyber stalking, harassment. Now, Pakistan enacted the cybercrime law, but I'm obviously going to talk to you about a criminal piece of legislation which was enacted, and the narrative around this was that, women are harassed online, there is no legal recourse, and you need to have legal recourse. And within it, not only were there various offenses that were defined, and this was enacted in 2016, so we've had a 9-year run of this law, but also in it was the illegal content powers given to the regulator, right, in terms of takedown request to companies. The difference in Pakistan is, and I mean, of course, here you'll have a physical, legal, and corporate presence of companies. In Pakistan, you don't have big tech, which is incorporated. So essentially, what you rely on are platform moderation policies and what falls foul of their community guidelines and how that gets implemented. And one of the primary complaints is the turnaround times, or what is recognized or not recognized, just, in the policies. Just to give you an example, again, context matters, right? So in a society where largely patriarchal honor codes are followed, if somebody is being impersonated, a girl is being impersonated and her picture has been uploaded, and it's not in a morphed, sexualized image even, but just her presence, mere presence, can create conflict, and that could actually lead to a life-threatening situation. To explain that why is it necessary for this to be addressed in an urgent manner is also a challenge, right? Then comes reliance on law. In my view, and especially having been there when the law was being introduced, and again, what Asha also mentioned, striking the right balance, right, between freedom of expression. Here was a law that obviously we, being a journalist coming from the CSO sector, knowing full well how freedom of expression is curbed, our apprehension was that this is also going to be used to crack down on dissidents, which it has. How are you going to balance while, when you're creating the law, the offenses, the powers that you're giving investigation agencies, et cetera, how are you defining certain offenses, right? It can't be brought in as a criminal piece of law. But the narrative that was being pushed at the time by the government was that, well, women need safety. So anybody who was raising these concerns was like, oh, but you don't want women to be protected online, and that's sort of the blanket criticism that came. So the law is enacted, and of course, as expected, there is a crackdown on dissidents. But what we did not at that time, and I'm talking about pre-Me Too, Me Too happens to 2018. When Me Too happens, post that, so Section 20 in the Prevention of Electronic Crimes Act, which it's called, the language is if you harm the reputation of somebody, right? Now, harm to reputation is a very, very wide phrase. While we saw that in the political context, we saw a flurry of cases where women who had made claims online of sexual abuse or harassment or assault, and where they had named people, immediately the investigation agency started complaints. They started issuing notices to them, so call-up notices. We also then saw these being converted into FIRs, which means that the criminal process then, there's a formal charge against you. And despite the fact that this is, so just in terms of the legal distinction between a cognizable and a non-cognizable offense, so this is a non-cognizable offense, so you have to first go to the magistrate, get permission. That's not the process that was being followed, because cognizable offenses that give the investigation agency the power to arrest were added, and so there's no judicial oversight in the manner in which so this was, again, weaponized. And so in 2022, I had written a report on the weaponization of the cybercrime law. The intent, though while we were clear that this was for dissent, but when they gave it this narrative wrap of this is, again, protectionist, right? So it wasn't about autonomy, agency over it, but it was very paternalistic, protectionist approach towards it. Obviously, there were other aims, and then it got weaponized against not just, of course, women, but also those who spoke up in support of them, right? And so we saw a vast array of these, some more private, some more public, including celebrities as well. So the question really is, our over-reliance on law, especially when we also, the narrative push, and I know it comes from advocacy circles, but let's criminalize things. The other thing that tends to happen, so I've been following cases and also assisting victims of harassment online. So there was one case where a female professor, her morphed images over sexualized, obviously images were posted to her university pages. Now it was by an anonymous Facebook account, and this is now 2016. She reports the page. The other challenge also is that you have to guide those who are filing complaints. If you want legal recourse, you can't have the platform take it down, but for traceability purposes, you need to let it remain up so that they're able to find who's behind it, right, for the IP traces, et cetera. And that's a challenge, because the first thing that anybody wants is for that to be removed and go away, right? But then what happens when it comes back up. And that's what happened. Initially, she started reporting to platforms. It got taken down. More sprung up. These are anonymous accounts. Finally, she reported to the investigation agency. And again, I mean, based on, officially the IP was handed over, matched the subscriber address. Now, here's the other challenge where the subscriber addresses of the person in whose name the internet connection's registered. 5 people in a household will be using the connection, but the trace will first lead back to the person in whose name it's registered. Anyway, as things developed, it was one of the brothers, according to the investigation agency in court records, who said that it was him. The criminal proceedings go on. The problem is, though, that it took 5 years to get to a conviction in this case. And also, the investigation agency, which was supposed to help, the state was a party in this case, and this was one of the offenses which was made cognizable because a lot of times victims or complainants are pressurized to withdraw cases or then they resile. And so here the state was a party so that that doesn't happen. But then the investigation agency lost her evidence file, and I say lost it with sort of inverted commas because you lose the primary evidence, and then there's the facilitation on the other side depending on who has more clout. The harassment and the re-traumatization through that criminal justice system, and this is one image. Over a period of time, so many things happen. How many things can you possibly take to a regulator, to a law enforcement agency, to platforms? Women journalists in Pakistan came out with a statement in 2020, and for expressing their opinion, for doing their jobs, there are death threats, there are rape threats, there are gender-based slurs, right? And while I completely understand, the distinction between is it illegal, but it is harmful, but is it illegal, should it be illegal? But there's a psychological impact. I know a lot of journalists who then switched off their mentions, right? Or they went off platforms, or they reactivated their accounts. And even if they are not there, their images, their videos are still on social media. You can't escape it. And so what do you do in that instance, and how much do you keep reporting? So the challenge really is it can't be over-reliance on law. There is a traumatizing sort of criminal justice system impediments. If you don't fix that, you can bring any law that you want. It's not going to create recourse. And then again, platform policies, recourse, what happens, and you're trying to find the right sort of balance. There's still more questions and answers. I mean, the problem is it's ongoing, and you see now with deep fakes and AI and everything, that's added a whole new dimension to it. One way, again, to, you mentioned this about, public dissemination and those distinctions. We saw that in the law as well, where if it's public transmission, the judiciary I have seen in cases where they've seen, well, okay, even if it was a picture that was sent to person A and that was consensual, but if that person passed it on, even privately to somebody, the judge saw it in a manner where that was a transgression, right? But then again, it becomes case by case, right? How do you ensure that there is an environment? So I was at a judicial training, so these are trial court judges on the cybercrime law, and their question was, well, can we deny, so there's a process with supply of copies where the accused has a right to the copy of the file. But their question was, well, there are graphic images, which is, can we withhold these images? Can we not give it so there isn't further circulation? But the problem is that then you're going to impact the rights of the accused as well. So they're looking for ways, they're looking for guidance on what is it what can we do remaining within sort of the parameters, right? What are best practices? How can we ensure that if women do ultimately go up to the investigation agency or do come to court, how can we facilitate in a manner where they're not further traumatized through the court process? But at the line of questioning, the evidence going into all of these different hands, and then finding their way online as well, which also tends to happen. And these are also just sort of the complexities that we've seen over a period of time where law in and of itself will not solve anything. It's also the procedures, it's the rule of law environment. But even then, even the best intentioned law or agencies, et cetera, will not be able to, because there's other dimensions to it. There's the corporate aspect to it. There's a social. I find, like in the Pakistani context, that we try to solve every social problem through the law, and I think that's a flawed approach. You can't. Some of it will have to do with social conversation and evolution, and that's a parallel sort of approach, right? All of these things will have to work in tandem. So this is just to sort of try and link sort of some of the things that came up here, just to give you a perspective of how it is still. And we've had more amendments to this law recently, and a new social media regulatory authority. And that also, for us, is of a little bit of a concern in terms of blanket power, how much the executive, because you do have to see both sides, where yes, you want certain things facilitated, but we tell victims, if you want something taken down or restricted, then approach the platform directly. Because if it goes as a law enforcement or regulator request, then it's going to be treated very differently.
Thank you very much. I think this was indeed very useful to have more examples and different perspectives. And I had a little question that came to my mind. You said law can be weaponized, and I think Asha, one of your points is that the DSA could also be weaponized. And I wonder, has it been yet? Maybe the good news is that not yet. It has not been weaponized yet. We know the GDPR is accused of being weaponized, the poor GDPR. But so the DSA, I think we are, for the moment, nothing too serious happened. It doesn't mean that it could not happen. But overall, if we look at only the beginnings of the implementation, it is sort of reassuring, is it? I don't know. It's a real question. What do you think? Are we reassured?
Sure, I can answer that. And just to clarify, it was the directive that I'm concerned about being weaponized. Whether the DSA will be weaponized is also another bigger conversation we can have. But it's precisely this. These are the kind of concerns that we have. And so when you have civil society organizations who are advocating for platform accountability, good platform governance, as many have been doing for a really long time, I think we forget, we're now talking in this context of we have the DSA and we have the directive, but it's not that long ago that none of these frameworks existed, right? We were still relying on, e-commerce directive and kind of the goodwill and due diligence of companies under the UN framework on the guiding principles on UN on human rights, and that we kind of had to go through those measures, right? And I think it links very much to what you're talking about and having to navigate how to go through platform content moderation practices and reporting to be able to get content taken down. But just to come back to this question on this reliance of law, because this was something that we were flagging, and I think a lot of where the intersection with some of the advocacy of women's rights organizations at the time, we were also saying not everything can be criminalized because it's not appropriate to be criminalized, because we are concerned about the use of legislation to kind of repress and chill speech. I think just generally speaking, thinking about empowering executives to the level in which they also don't have accountability and can use these in a way that's not useful. I think we always get the message of we're the good guys. We're not going to do anything terrible with this legislation, but sorry, I don't believe that. And two, we don't know who will be in power in the next iteration. I think let's look at the geopolitical context right now and think about where we are and how those things can get used. But I very much agree in regards to the fact that even though some elements cannot arise to the level of being criminalized, we still need to address it through those mechanisms that we have in place. And my argument, though I may be slightly biased on this, but my argument is that online gender-based violence in the context of the DSA is the strongest example that we have for why platforms should do risk assessments using an intersectional methodology. Because online gender-based violence can result in the infringement of the right to participate in civic discourse for women and gender non-conforming persons. It infringes on the right to non-discrimination. It can infringe on the right to an array of fundamental rights for those groups who are impacted. And of course, GBV is also very specifically mentioned in the Digital Services Act. So I made the argument that, well, if you're going to do a risk assessment on online GBV, why don't you do it with an intersectional methodology and see how it intersects with the other risks that you have to be able to assess and address. So I think it gives us that concrete example because it is this, what you were talking about in terms of the experience of online gender-based violence varies depending on your intersecting identities, your communities, your language, your physical location, your political alignment. It can really vary quite a lot. And so seeing whether the DSA can be used as a tool to address that is interesting, but sadly my concern is that it's not being prioritized as of yet. I hope it will be. And there's a big disparity between the enforcement regime that sits behind the DSA and the enforcement regime that sits behind the directive, which is a directive. And just to point out, a lot of resources have gone into DSA enforcement, but I believe under the directive at EU level, 1.5 persons has been designated to help all EU member states with the enforcement of the directive.
Maybe they are very talented.
Right, maybe, and I wonder how that's going to work. But it's a huge disparity, and you can see where the prioritization has been left.
So the good thing about the directive that it does mention intersectionality.
It does,
yes,
yeah.
So that's Alexandra.
I would just maybe like to add here, Asha, what you mentioned earlier, that some of the VLOP platforms actually rolled back some of the measures. And here, it's not like they use DSA as an argument, but very much, oh, we're trying to protect freedom of expression, and we don't want to limit expression of our users, right? And suddenly allowing, all sorts of content that previously was not allowed with regard to harassment of women, but also LGBTQ communities. Suddenly, since January this year, this is all okay with the principle of more protection for freedom of expression. And I maybe want to add one more thing, that not relying on law, but more on platforms and practical measures, if they have them. A lot of policies and a lot of content moderation practices of platforms were actually a result of harassment of women on them, right? I mention often here the Gamergate, which happened 10 years ago, 2016, 17, with this massive harassment of women game creators that was happening in the US, that was on Twitter, and then, what was it, Reddit, or, and the 8chan, I think, at that time. And that actually led to huge harassment campaigns where people had to relocate, they had to change addresses, pictures of their children were posted online. And that actually led to introducing some measures like blocking certain users or hiding your account from others. Before that, it was kind of like, we're this great community and we're all nice to each other and everything will be okay. So a lot of these measures were actually a direct result of what's happening back then. So, we have lessons to learn, and it's really terrible to see that now this is being rolled back for, but I do not definitely blame DSA for this. There are other reasons that you mentioned. Yeah.
Thank you very much. I wanted to quickly come back to the Italian case as a case study of this situation where EU law does this, and then suddenly member states are free to come up with a solution that seems not very useful. This concerns enforcement, so sanctioning, but potentially also the authority that can help you. I think it's important that you know as an individual who can you call if you have a problem, and this has to make sense. So I don't know which, because you were mentioning we like EU law a lot. So if at the European level, something could be done or should be done to make some sense of this specific issue. What would be your wish, or do you think it's feasible that we make some sense out of the situation?
Well, I think that probably there should have been smarter decisions at first. So clearly now we're coming later. Probably one solution could be actually indicating competent authorities to establish protocols of memoranda, try to strictly cooperate. This could be one possible way forward. And probably also, asking member states to empower authorities who are actually in charge of some parts of these competencies. And this is actually something that really worries me in future, because from a really pragmatical viewpoint, like if I'm an individual that have actually suffered from a form of abuse, who should I be talking to? Who's my point of contact? And this also worries me with regard to also the AI Act competence and enforcement, because at least in Italy, probably the way forward will be that the market supervisory authority will be another authority. And this authority will have important, of course, powers with regard to market surveillance. And we've seen cases of deepfake technologies being marketed and spread and developed around. So yes, this is for sure one of the most important challenges here. And yeah, guidance should really look forward to ensuring really close cooperation among authorities. Otherwise, yeah.
Is there any message from the other speakers, anything that you think will really make sense, or even which type of authority should ideally be empowered to take a different kind of attitude?
Well, that's a big question. And I'm going to put an asterisk next to my statement of loving EU law. I like assessing it. That's more, maybe a bit more accurate. This is really difficult because the DSA is the DSA that we have, right? We have the enforcement structure that we have, and it's complicated and it's complex, and it is based on a concept of cross-border coordination and coordination between authorities that has to be inherent for it to work. Prior to the DSA being finalized, a lot of civil society organizations actually argued the fact that there needs to be a separate entity to do the enforcement of the DSA. Much like the European Data Protection Supervisor, for example, it needed its own legal personality to be separate, to have the independence that it needs to be able to do that particular job, because it's very complex thinking about doing this. And so we have a few questions in regards to kind of how that works, right? There needs to be a massive pull-in of expertise to be able to help address these. I think many of you will know there's, the DSA enforcement team is like looking to bring in a lot of people right now who have this expertise, because you need that. If you're looking at a risk assessment on gender-based violence, you need to kind of have a bit of a lens and understanding of what it is that we're talking about here in order to ascertain, is this risk assessment any good? Are the mitigation measures that they're putting in place any good? But at the same time, an enforcement body won't have all of the expertise that it needs. And so this brings me back to a pivotal point that's, a driving force for a lot of the work that CDT does on the DSA, which is about civil society inclusion in the oversight of the enforcement of the DSA and kind of monitoring implementation as well. The Digital Services Act mentions civil society engagement more than any other regulation I've worked on. I think in many contexts it mentions it more than any other EU regulation that we have, and there's a reason for that, because I think the legislators understood that you would have to draw on that expertise and have that third-party oversight in order to be able for it to function properly. So far, that hasn't been maximized on as much, let's say, by the platforms in terms of, say, consultation on the risk assessments, for example. There haven't been many opportunities to do this. Thinking about the diversity of organizations that need to be consulted, we mentioned women's rights organizations, but digital rights organizations, LGBT organizations, a lot of them have perspectives that are useful to kind of bring in. But it's the same thing for the regulators, right? They need to be able to consult with these experts who've been working on these issues for decades at this point, truly decades, and have a very intimate understanding of what it is that we're talking about, to be able to help them inform their enforcement decisions, but also to hold them to account also as well when we feel like enforcement is not being centered on a human rights approach.
Yes.
Not so much about enforcement, but the usefulness, let's say, of the AI Act to address this. So if I understand, and then thinking specifically about AI created deep fakes, deep nudes, deep pornography, if I understand correctly, this is not going to be very helpful, right? Because this is not a prohibited practice. There are only transparency obligations. So, if you're a victim of this, is that really going to help you if there is a little disclaimer that this was created with AI? I don't think so. And then of course we have a household exemption here. So like most of people who do that, this is not the professional deployers of AI systems, but people who do it at home. So like the whole AI Act, as its usefulness to address that problem, I have very serious doubts.
Good. Maybe before we keep the continuing conversation, it's time to open the floor for questions. Yes, I see one. We will take 3, and we will continue later. And then we will come back to you later. Yes.
So I wanted to ask what reassurance or guidance you might have for victims, because this is a real issue. I've opened my social media today and I've had 4 comments calling for hate crimes against me, horrible things, swear words, profanity. That's today, this morning, we're just past the afternoon. You know, if I report this, nothing happens, but actually my page gets flagged, so I'm inhibited from engaging on online platforms, but that content's never moderated or taken down. One thing for me is that I don't feel like the law is powerful enough yet. By minute, these issues are only increasing, particularly with the prominence of bots and the influence of speakers out there, like the Tate brothers were mentioned, and we're seeing a lot of growing movement of incels, etc. So it's becoming very common for this to happen. Pretty much, I'm just posting up a cute latte, but people are calling for crimes to happen against me just because they don't like me. So I kind of asked, you know, what reassurance can you maybe offer women where the law is so far behind, but it's only getting worse minute by minute?
I think this was a very important question, but I promise I will take 3 questions. So there, and then the person in red.
Yeah, thank you very much for that great panel. I'm from Germany. I'm Christina. I have worked in gender-based violence online for 10 years. So thank you for this sum up. And a lot of times, and this is my question to you, I ask myself, on an analytical level, we already know what's happening all around the world besides the DSA. But what I lack, and what is my question to you, it's maybe also connected to the first speaker, is where is actually the education? We have all these laws, but in the implementation, but if we don't have people to speak up, know that there is this law, this framework will always between us experts and never to any woman or whoever thinks she's a woman or is by any gender harassed online through that. So I'm asking myself, this DSA, I see it in many levels. There is nothing in there that teaches people that the DSA of Europe is there and it's for them. So my question would be to you what you can bring into that, besides all the regulatory framework that we are in now in a kind of fine-tuning, where is what decision made, is actually how can we get it to the people?
Thank you very much. And the third question, I think, is Maria. Yes, I still have some good, it's at the end. And I see the others. You're the fourth, no worries.
Thanks so much. It was a very interesting panel. I have maybe a follow-up question to what Alexandra was saying about the freedom of speech balancing. I was curious, is this discourse have any potential being implemented to the EU? Because I understand it's copied from the US and the companies try to push it, but I was wondering, is there any possibility they will actually succeed, in the sense like are the courts going to share this balancing already and what's happening there, maybe in the case law? And the second question was more about, perhaps similar to the first one, was about this enforcement and effectiveness of it, because as I understood from your discussions was that this problem is on the one hand very systemic and very individual on the other hand, and it's very hard to balance how to enforce that. I understand there are some ideas on the systemic level, but I was actually wondering how it is for this, on this individual grounds, what's there for these victims to do. And yeah, so I was curious to hear your thoughts.
Thank you very much. So 4 questions in practice. Who wants to start? We will take the other questions after.
I just quickly want to address what, the first question. And again, this is precisely what, I'm sorry there won't be answers because we ourselves are searching for those answers, but this is a classic problem that you don't have a redress mechanism that effectively, in the timeline that you require, addresses the user concerns, right? This has happened in the morning, you're in the afternoon, multiple things will happen every day. How much can you humanly report the time between the reporting and when it gets addressed. And so that's the challenge, which the companies will also have to more proactively respond to, because the law alone or the companies alone will not be able to. We will have to find those mechanisms where this happens, and law can't be offered as an illusionary sort of solution, because when people go to the second lady also mentioned that there's a law, but people don't know about it or how to access those mechanisms. And then when you have a law, you need resources and capacity there to deal with the volume of complaints that will come. And if that doesn't happen, then again, there'll be no access to recourse, right? So we can enact laws and we can have policies and we can have mechanisms, but if they don't work to address the issues, which will keep changing, technology will keep changing, which is why I think the law should not also have very specific terms. So I'm not saying that the law should be broad to be misused, but it should be broad enough to take into account the change of medium, so that by the time you legislate in another 5 years, technology and the medium has overtaken you. So you need to be able to factor all of those things in. But I want to underline, redress mechanisms are missing at the moment. How do you serve the user? That's something that neither, in my view, the laws adequately address, and nor platforms. And that's something that we need to look into.
With regard to the question on freedom of expression, it's true, yes, this is very much narrative coming from the US with this free speech absolutism perspective. Here in Europe, we generally go more into balancing of different rights at stake, and with the European Convention on the Protection of Human Rights, Article 10 in paragraph 2 allows restrictions when they fulfill certain conditions. So I would hope that we do go for a more balanced approach, and if the right in conflict is protection from illegal content or from illegal activities towards a person, that would be taken into account. But at the same time, I think we can see that among general audience, this is something that catches up easily, right? And it's not only about gender-based violence content, but it's the same with disinformation. It's about harassment of people of immigrant origin, bunch of other types of content where regular people, let's say on the internet, but I'm being silenced, I'm being censored here. So I think there is very much the risk that how that could impact people's behavior. But also electoral choices, for example, like for candidates that, no, we should have more freedom of expression because right now you cannot say anything on the internet. And that is scary. I would maybe also want to add something about the education, although not so much education about DSA, but education more broadly. So, media literacy and education of media literacy is kind of a concept that is mentioned a lot, and I'm not sure if, there's a lot of meat. I mean, there's a lot of attempts, but I hear also when talking to like sex workers community that for many of these issues, you need education, you need something in schools, including education on healthy sexual behaviors and not hiding from this conversation. And that would help addressing the problem on a more systematic level, because we're talking about gender-based violence online, but this is very much related to gender-based violence offline, because these go together. This is not like two separate things. And a lot, like somebody mentioned, the incels and groups like this, that we need to start looking at education, offline education, and also education with regard to mental health. So those are all complex discussions, but I think we have to look at it together.
Yes. short answers so we get more questions.
Sure. I'll try and be really quick. First of all, I'm very sorry that that was happening to you, and it's far too common. I think it actually links to the point that someone else made about it being systemic but also individual. It's specifically happening to you, and you're feeling this. So first of all, I'm very sorry. The first thing I'd say is there's actually a couple of platforms I'm going to direct you to. Take Back the Tech, and there's a couple of others that I would engage you with. They have this amazing campaign where when you reach out to them, they can actually come to your page and flag content as a kind of bystander initiative. So it's not just the onus isn't on you, it's just you've got a community who will come and support you, support your page. They also used to just drop lots of hearts and stuff and remove comments, help get comments removed. So I can talk to you afterwards about some of the communities that are out there specifically to help for victims who are experiencing this. Just to say, in terms of what you're experiencing and kind of the threats to life under the directive, that would be a form of illegal content and could be criminalized. The directive doesn't come into force until 2027, but there are things in place. But it does go back to this thing of the over-reliance of law. And I wanted to come back to what you just said very quickly, in that we've had gender equity laws for 60 years, 50 years in some places. And would it surprise you to know that patriarchy and misogyny and sexism still exists? It's a surprise. So in terms of how effective those laws are, it's always that question of what are the other mechanisms that we have to use to address this. And it goes into the fact that we're seeing one of the largest generational gaps right now between ethical and political ideologies. We talked about the Tate brothers and others, but you can see this massive gap and I think it needs to be addressed also as well. Very quickly on education, there's a role that civil society organizations and campaign organizations play in raising the awareness on certain legislation, but it's also up to the EU lawmakers to raise the fact that these laws exist and they're in place. They actually have a role and a fundamental need to raise the fact that they are there. And then very quickly on the freedom of expression question, I don't know how much this has come up in other contexts, I'm sure it has, but we're looking towards the kind of attack of the current administration on free expression. We know that there's been some letters specifically attacking the DSA coming from the current administration, but that's also being echoed by certain parties in the European Parliament right now. We are not detracted from that conversation, and the DSA is being touted as this weapon of censorship here too, so we have to be very aware of that too.
I'll answer briefly to the second question. I completely agreed with you. The problem here is deeply cultural. And of course, I agree with the other colleagues when they say that, of course, also the answer cannot be purely and merely legal. Law is one instrument, but has to be enforced and used also in a multidimensional approach. Education should be really also at the core of the mission of authorities who have been tasked to protect victims. I can speak for the experience of the Data Protection Authority. There are actually many initiatives to raise awareness regarding these issues. There are informative campaigns around Italy. We go around regions and cities to inform. We go in schools. However, the problem here is often financial, and the fact that authorities remain quite understaffed and under-budgeted with all the tasks that are assigned. But I completely agree here. The mission is also highly educational.
Thank you very much. I will take two more questions. The person who was very insistent and somebody from the left, because I didn't get anybody from the left. So for the moment, yes, I know. If they are very short, I'll get a third one.
Thank you, Christos Velasco. Thanks for your interesting insights and conversation. I mean, I find it very fascinating, especially, the cases happening in this part of the world. Pakistan, sorry. It's interesting to see, no one has really touched upon the issue of digital evidence. Most of those cases, when they are actually brought to the police, some of the victims are re-victimized because they don't believe that the evidence that is actually presented, even if it's a photograph, a screenshot or whatever, is not sufficiently proof of evidence. And this is interesting, and this is some of the things that many, many different law enforcement authorities are running across the world to actually resolve these cases. What's interesting is also, we have cases in Latin America. There's hope that some cases are being taken, very investigated. But unfortunately, the response of the law enforcement authorities have been somehow slow and not sufficiently well adapted. So my question to you is much more on the evidence issue. How do you see, like, the role of, of the evidence that is presented at the national level to the police and the law enforcement authorities will play a role sufficiently to resolve cases of cyber violence?
Thank you very much. The second person was here in blue, here.
Thank you. My question is about surveillance, like capitalism, and how the digital platforms are used to, like, basically group polarize and echo chamber the platforms. Basically, after the the Twitter's acquisition by Elon Musk, most of the platforms end up being more like the content change, the more right-wing way, and their promotion of different kind of like ideologies and such. And this is basically based on the sanctifying interaction and increasing screen time and more interaction by certain genders as well. And this might cause like more hate crimes and, let's say, more men looking at more hate crime like content based on women. So my question is how the algorithm can be like regulated or like this DSA can be used against this.
A very last, very short question from there with the glasses. And then we will get very short answers.
I wanted to come back to the topic of trusted flaggers because we mentioned the collaboration with the civil society, and my fear is that states are going to select which NGOs are going to cooperate with platforms because they are the states nominating the trusted flaggers, especially when we talk about like porn and sex workers organizations. We know in France, these organizations will never be designated by the state.
I take this as a question, so you have 1 minute each. Who wants to start?
I'll just quickly do the evidence question, right? And this is something we're dealing with. Of course, the first piece of evidence you will take is if you felt aggrieved by the content, that's what you're going to take to the investigation agency, at least in my experience how it's played out, is you'll give them the live link, you will present a screenshot, put it all there. But again, whether that constitutes the offense or not, is something that sometimes can fall into a gray area where you might feel offended by something and feel that it does qualify, but when they look at it legally in terms of the language, whether it does fit or doesn't fit the scope of the crime, and that's a whole different thing. But then again, in terms of that evidence, once it's there, and even if it's been accepted in the case, the concerns with especially sexually explicit images are that how are you going to make sure that it's not further disseminated, whether within the investigation agency itself, not beyond your investigation officer, but also when it goes to court, it becomes a public file. How do you contain that? And this is something I reference that judicial circles are talking about. But then again, digital forensics, to actually ensure that when the forensic report comes, and if the forensic report is really the crux of the evidence when you lead the trial, but if there's tampering there, and I've seen it happen in cases where judges are not equipped, they can't, we are also not, even we might be in the tech space, but for you to know whether a forensic report has been tampered or not, right? And so you might have had all the evidence as the complainant to begin with, but during the course of that trial, things change so many hands, and things happen that by the end of it, you might just stand at a disadvantage and not because you've done it. So I think digital forensic evidence, all of this, and safety is a huge, huge subject which could be a whole discussion.
I'll take the last question about trusted flaggers. Very good point, and I think this also comes up all the time, that we need broad stakeholder involvement and not just stick to this idea that, ooh, sex is bad, so we're gonna, not talk about it in schools and not involve organizations, but that's the only way to actually address it and indeed make change and create, also change at offline environment. So that's gonna be very short.
I'll be super, super quick. I'll address the algorithmic transparency aspect and the testing there. The DSA does require it. Under the risk assessments provision and the mitigation measures, it does actually require platforms to assess and mitigate the potential risks that they have or contribution to the dissemination of systemic risks that their systems may contribute to. Saying that, we don't think that they did this in their first risk assessment reports, but they are required to do it, so it is there. On the trusted flagger point also as well, we were also very concerned about this, also because under the DSA, the trusted flagger provisions is very resource intensive on the trusted flaggers themselves. There's a lot of reporting. But we were also concerned with not only certain NGOs being designated as trusted flaggers, but we were also concerned with law enforcement units, like internet referral units, who also then, as part of law enforcement, could then also be the entity that sends Article 9 and Article 10 notices, and so we were worried about a bit of a rule of law lapse there. But you're very right, and so there are organizations who are thinking about this concept of how to create a kind of knowledge exchange and capacity building exchange between other NGOs so that they can become trusted flaggers.
Nothing. Oh, no, I have 1 minute to thank you all. Before I thank you, I saw there is a panel tomorrow, I think the first slot, an interesting panel about this subject, also organized by some friends. I would recommend that we all wake up tomorrow morning and we keep discussing this subject. For the moment, just please let me thank the speakers very much for their contributions and see you around. Thank you all.